Hi, I'm Jon Wright, a director with the intellectual property law firm of Sterne, Kessler, Goldstein Fox. We just passed the one-year anniversary of the Patent Office's implementation of inter partes review proceedings. Based on our participation in over 40 proceedings, our review of hundreds more, and recent feedback from the board, we've compiled a series of tips for preparing IPR petitions and patent owner preliminary responses. Today, I'd like to offer 4 tips on preparing a successful petition for inter partes review. First, stay focused. Structure your challenge and make a complete and compelling case around your strongest prior art. The page limits simply do not allow for a scattershot approach. If you can't determine your strongest argument, the board will do it for you. We've seen case after case where the board reduces the grounds for trial by selecting what it perceives to be the 1 or 2 most compelling grounds for rejection and labeling the rest as cumulative or redundant. If you feel compelled to rely on more than 1 or 2 primary references, take the time to candidly explain why multiple references are necessary and not cumulative. Second, be thorough. Make it as easy as possible for the board to verify and adopt your proposed rejections. Provide detailed citations to your evidence. The board will typically not fill in evidentiary gaps in your proposed rejections. Third, use declaratory evidence wisely. Most petitions include declaratory evidence. The board finds this useful where the technology is complex and concise technical tutorials are appreciated. Declarants may also explain how one of skill in the art would have understood key claim terms. The following 3 things should be avoided: conclusory statements, opining on patent law, and argument that is couched as declaratory evidence. This third item could be perceived as avoiding petition page limits. Finally, follow the rules. Strictly follow all the formatting rules and ensure that petitions have all of the required sections. For example, do not, as a petitioner, attempt to provide your mandatory notices in a separate pleading. They must be part of the petition. Claim charts are another item where the board looks for abuse. Single spacing is allowed, but use a 2-column format and do not include argument or claim construction. Early on, the board was lenient. Now there is sufficient guidance in published decisions so that little ambiguity remains on what is acceptable petition practice with respect to formatting. I'll end with one final observation. The board's rules explicitly state that the rules will be construed to secure the just, speedy, and inexpensive resolution of every proceeding. That's Rule 41.1b. The only way the board can achieve this mandate, given the rapidly increasing number of filed cases, is to ensure tightly focused proceedings. The board's first and best opportunity toward achieving that goal is with its trial decision on your petition. Your best chance for success is to help the board get there with a focused, tightly constructed, fully compliant petition. Thank you.